Hello and welcome back to my channel. Well, I want to talk about the outcome that occurred in the federal court between Porter and the Australian Broadcasting Corporation. There was a decision that was handed down by Justice Jaggett yesterday that has left a lot of people stunned, myself included. And I'm not a lawyer. I'm not a lawyer at all. I have no idea. I believe that there is some legal stuff and there are some legal reasons for this happening. However, for me, I find this to be quite worrying, what's happened here. So let's have a look at it. Let's work our way through it. It's 117 pages. There's a lot of court jargon here. My hope is that I can sort of bring it to, try and stop the legalese a little bit and try and explain it in terms that maybe we can understand to see whether we can in fact understand it. So essentially, there has been an interim suppression order on the defence that the ABC filed in the defamation proceedings. Now, the unredacted defence was made public in the Dyer Chrysanthi matter, and part of the settlement between the ABC and Porter was that ABC would not refer to what was in that defence, and that they would ask for the court to remove the defence from file so that nobody would ever see it again. Now, just because it's removed by file, so it's going to be sealed in a storeroom somewhere, and the only way it can be viewed is if somebody applies via court order to view it. So the court has to actually decide whether somebody has a good reason now to see it. Now, the day before this judgment, Her Honour, Justice Day, had actually made orders for the South Australian coroner to have the unredacted copy of the defence so that the coroner could investigate the cause of death, look into the investigation of the death of the alleged victim. Now, what's going to get very interesting is if the coroner decides that there is something, that there was an involvement by Porter. It's going to be interesting to see what's going to happen now, because, and this is where I find that this judgment is a bit, it's going to get very messy. If the coroner in South Australia says we think the actions of Porter contributed to the death of the alleged victim, then we have another ball game. So I find it really interesting that the day after this order's been done, that this decision came about. So let's have a look at it. So where parties settled proceedings, where interim suppression and non-publication orders were made, where parties proposed consent orders, including order to permanently remove unredacted pleadings from court file, where such order is an important aspect of compromise between the parties, where such order would prevent public from inspecting unredacted documents under the principle of public interest in open justice, fundamental not absolute, court to facilitate just resolution of disputes, unredacted documents to be removed from court file on the ground it is necessary to prevent prejudice to proper administration of justice. That was what they were wanting. So then we've got all the practice and procedures and all the legislations and then all the cases that were cited. All right, quite a few there. Okay, so it's New South Wales. This hasn't really, I've tried to get this to go better, but it seems to be cut off a little bit, and I don't know why. So we've got we had Mr. Brett Walker SC for the applicant, and remember that he's replacing Sue Chrysanthi, who was deemed she couldn't work on it. You got the ABC. You've got intervening parties. You also had Mr. Dowling. So you had a whole variety. I mean, you had the media, you had all the other media as well. So here were the orders that were made. It says the New South Wales District Registrar, so the court orders that the New South Wales District Registrar cause a copy of the unredacted defence filed the 4th of May 2021 and the unredacted reply filed the 4th of May 2021 to be placed in an envelope marked NSD 206 2021 Charles Christian Porter versus ABC Corporation and Anor, unredacted defence and unredacted reply removed from the court file pursuant to orders made on the 30th of July 2021, not to be opened or made available for inspection by the public other than leave of the court. So you're not going to be able to see it. The envelope referred to in Order 1 be sealed and stored by the New South Wales District Registrar in the New South Wales District Registry in a manner and location as decided by the New South Wales District Registrar. So the registrar can decide where they're going to go. The interim suppression and non-publication orders made on the 10th of May 2021 and subsequently amended on the 21st of May 2021, 25th of May 2021, 28th of July 2021 be revoked. Order 3 be stayed for a period of 14 days. So this is the interlocutory application filed by Shane Dowling on the 11th of May be dismissed. Shane Dowling paid the costs of the parties of and in connection with the Dowling interlocutory application. The intervening parties and the parties each pay their own costs of and in connection with the hearing on the 9th of July and all related management hearings. The intervening parties and parties may seek to order Order 7 by filing and serving within 7 days. Written submissions not exceeding 2 pages set out varied order sort and reasons. So they have 7 days. So at the moment they're saying they've got to pay their own costs. If they want there to be any change to that, they've got 7 days to write to the court and tell them. If the intervening parties or parties file and serve any written submissions under Order 8, the other parties and intervening parties may file and serve within 7 days a written submission in response not exceeding 2 parties. So if somebody then does say that they want the order, they don't want to pay their own amount, and they want the other parties then get another 7 days. So we've still got something like 14 days to do it. Still got 14 days in which that we can do it. Okay. So then we've got that the court orders by consent that leave be granted to the applicant to file a notice of discontinuance within 7 days on the basis there'll be no orders of cost. So Porter now has to file a discontinuation. So he now has to say, I'm discontinuing this. That the unredacted defence and unredacted reply be removed from the court file. No Order 11 is made on the ground that it is necessary to prevent prejudice to the proper administration of justice. Entry of order is dealt with within 39 point of the Federal Court Rules. So now we're going to get into the background of it. So the unredacted defence is now put away, and you actually have to apply it via court order to see it, which I find to be very, very interesting, to be honest with you. As I said, I'd be interested to see what you think about that, because, considering that there are people, the coroner, the South Australian coroner, for example, has stated that has now got an unredacted copy. So This proceeding involves a claim for defamation. The parties settled the proceeding on the 31st of May, and they forward an agreed email to the court indicating they would be grateful if I made orders by consent in the chambers as follows. That the proceedings be discontinued, no orders for cost, that the unredacted defence and unredacted reply be permanently removed from the court. And the court notes that the first respondent agrees to the following publication. On the 26th of February 2021, the Australian Broadcasting Corporation published an article by Louise Milligan. That article was about a letter to the Prime Minister containing allegations against a senior Cabinet Minister. Although he was not named, the article was about the Attorney General, Christian Porter. The ABC did not intend to suggest that Mr. Porter had committed the criminal offences alleged. The ABC did not contend that the serious accusations could be substantiated to the applicable legal standard, criminal or civil. However, both parties accept that some readers misinterpreted the article as an accusation of guilt against Mr. Porter. That reading, which was not intended by the ABC, is regretted. In an email, in response, I said, Justice Jaggett has considered the proposed consent orders. Her Honour notes the following. The necessary order is that leave be granted to the applicant to file a notice of discontinuance within 7 days on the basis that there be no order to costs. Her Honour has no issue with the making of an order in the amended terms. Order 2 is appropriate. Her Honour has no issue with making an order in these terms. Justice Jaggett's present view is that Order 3 cannot be made merely by consent between parties. Her Honour's present view is that the intervening parties may still have a right to be heard about any order continuing or having the effect of continuing the suppression orders. Mr. Dowling's interlocutory application also remains unresolved. I also informed the parties that as a result, the proceeding would remain listed in open court the following morning. The parties responded to the effect that they agreed that Order 1 needed to be amended as I proposed. As to proposed consent Order 3, they said in relation to Order 3, the ABC has agreed as part of the settlement of the matter to unredacted copies of the defence and the reply be removed from the court file. As such, in the parties' view, if Her Honour were to make this order, the question of suppression would no longer arise. This response did not answer the issue of concern. The issue of concern was the appropriation of making consent Order 3 at all, or as proposed in chambers without hearing from intervening parties in particular. Also, it may not necessarily be the case if an order for removal of a pleading from the court file is made, the question of a suppression order does not arise. This is explained below. The evidence of settlement was filed in accordance with subsequent orders. On the 31st of May 2021, the parties entered into a deed of settlement and release. Recital G to the deed records that parties had agreed without admission as to liability to settle the proceeding on the terms and conditions set out in the deed. Clause 2.1 of the deed provides that the ABC would publish a statement within 24 hours in the form set out in Schedule 2 to the deed and permanently attach an editor's note to the publication of the subject of the proceeding, an article published on the 26th of February 2021 about a historic allegation against Cabinet Minister. Clause 3.1 provides that the parties would file the consent orders in the form set out in Schedule 3 to the deed, reflecting the terms of consent orders set out above. Clause 4 provides that, with effect from execution of the deed, Mr. Porter releases the ABC and Miss Milligan from all claims connected in any way to the publication. Clause 5 provides that the deed may be pleaded in bar to any claim which is released. Clause 7 relates to mediation costs. Clause 7.1 relates to mediation costs and is redacted. Clause 7.2 provides the quantum paid by the ABC pursuant to 7.1 will remain confidential and will not be disclosed subject to certain expectations. I thought, interesting. The intervening parties are Nationwide News Proprietary Limited, Fairfax Media Publications, and The Age Company Proprietary Limited. I granted the intervening parties leave to be heard in respect to of an interlocutory application filed by the applicant, Mr. Porter, on the 5th of May, seeking orders that Schedule 1, 2 and 3 of the respondent's defence be struck out under R 16.211 and rely on 16.21A, B and C and or F, that those schedules be removed from the court file under 16.212 of the Federal Court Rules 2011. Mr. Dowling filed an interlocutory application on the 11th of May 2021, seeking leave to be heard in respect of Mr. Porter's application for suppression non-publication orders under S37AF of the Federal Court of Australia Act. This is a reference to the fact that Mr. Porter also filed an interlocutory application on the 6th of May 2021 seeking orders under 37AI of the Court Act, suppressing the content of Schedule 1, 2 and 3 of the respondent's defence until further notice. In response, on 10 May 2021, I made interim suppression and non-publication orders in respect of 1, 2 and 3 of the respondent's defence, and at the request of the respondents, para 111 to PP and 8 of the reply to the defence under 37AI of the Court Act. These orders have subsequently been amended, but the amendment are not material to the remaining issue in the case, which is whether I should make Order 3 as proposed by consent between the parties. All right. So now, she's now just laying out how she's come to her agreement, how it's all going to go, and she's going through the different arguments. So, as at May 21st of May 2021, the position is that there is an undetermined interlocutory application by Mr. Porter. So then there was suppression orders. Intervening party has been granted leave to be heard. Mr. Dowling and the parties had settled the proceedings. So this is talking about she made directions enabling the parties to be heard and in an open court for the 9th of July to talk about whether the order should be suppressed or not. So she said, having now heard from the parties and intervening parties in the open court, reviewed the terms of the deed between the parties, I am satisfied that in particular circumstances of this case, as explained below, it is necessary to make proposed consent order 3 to prevent prejudice to the proper administration of justice. So now she's going to talk about why she made those orders. Now, to be fair, I can see where she's coming from. I understand that he's not been tried. They're all alleged. He's innocent until proven guilty. And from that point of view, but when you flip it to the other side and you go, you can feel very, very let down by the court. So I'm seeing both sides at the moment. I like to sit on the fence a lot, and I try to see it from both sides. But I really thought that for public interest and because of the fact that he's a politician and he needs to be held to account, and the way to deal with this is to, in my opinion, have an investigation to find out whether there is any truth to that. And that's what a lot of the politicians have been calling for, a parliamentary inquiry as to whether there are any truth to these allegations. And I think that's the only way to sort this out, to be honest with you, because otherwise this is going to be hanging over his head for the rest of his time. I did read in one of the court documents her goal was that he would never be made Prime Minister. I think that would be the case. I would like to think he would never be Attorney General again. But if he wants to be Prime Minister or the Attorney General again, the only way to do that is to clear yourself. And how do you do that? You put yourself out there for an investigation. And that's why I think it's really quite sad now that the unredacted copies are now hidden. So anyway, so she's talking about the Court Act. So she said, Except where, as authorised by this Act or another law of the Commonwealth, the jurisdiction of the court is exercised by judge sitting in chambers. The jurisdiction of the court shall be exercised in open court. So, yes, she did do an open court. So she's discussed jurisdiction. She's talking about the grounds of a suppression order and the fact that she's essentially showing that she's following all the court procedures, all the statutory requirements in this, and now arguing, stating that she's following the court rules. Because if there is going to be, if somebody was to appeal it, she's got to make sure that, it's, I was going to say, I want to use the word clad iron. She needs to make sure that her ruling, it follows everything so that there can be no appeal. So we've got the court rules now. She's going through the court rules. Now she's talking about the submissions that were received. She said the submissions from Mr. Potter were straightforward. It was further submitted for Mr. Potter that once it was accepted, it must be that the parties reached a lawful compromise of the entirety of the proceeding, including the dispute about the defence. The only issue was whether effect would not be given to lawful compromise on some proper principled basis. First, the court permits a document which enables a pleading to be removed from the court file. Second, there is nothing about the nature of the proceeding, a claim for defamation, which suggests the court should not give effect to the lawful compromise of the party. Third, there is nothing about the nature of the parties which suggests the court should not give effect to the lawful compromise that these parties are all equal before the law. Now, Porter's team had also submitted that really that the intervening parties had no right to be heard. That was part of their defence, so she's talking about that. Going through and now talking about the law, all the stuff that, all the cases that they cited and the law that they cited. Why? Now she's talking about intervening parties submitted that the effect of proposed consent order 3 was a de facto suppression order. It would mean that the document the public would ordinarily be expected to expect would not be available. It would mean derogation from the overarching principle of open justice, given that a news publisher has a right to be heard about any suppression or non-publication order. A news publisher should have a right to be heard. And don't forget, Porter is actually paid by the public. He's a public servant. So should stuff from a public servant be suppressed? So again, there's more court stuff there. More law stuff. The intervening parties referred to, again, all the court law, all the legal stuff. I'll put a link to if you want to have a read of it. It's quite a long document. And then more, so, going through the argument. So, the intervening parties also provided a helpful summary of case in which an order had been made for removal of document from a court as relied upon the written submissions for Mr. Porter. Another summary, so this one is Rio Tinto versus the Federal Commission of Taxation. Apparently predated the present rule. Again, more legal stuff. According to the intervening parties, there was no proper justification for making the consent order 3 as the parties proposed in the present case, as Schedule 1, 2, and 3 of the defence had not been filed for any legitimate reason. How new is that? Hang on. Okay. It says, according to, there were no proper justification for making the consent order 3 as the parties proposed in the present case had not filed any legitimate or filed for any illegitimate or collateral purpose. The material in Schedule 1, 2, and 3 of the defence were relevant to defence of justification. The defence was settled. The court had not found the material in Schedule 1, 2, or 3 of the defence to contain scandalous, frivolous, or vexatious material, or to be evasive or ambiguous, otherwise to be an abusive process of the court. So, and then again, material had been released in the proceedings 426201 Dye versus Chrysanthou, consequential upon Dye and Chrysanthou. Mr. Porter had pressed his application for suppression and non-publication order. It would have failed for lack of utility given the material already was released. Refusal to make consent order 3 as proposed would not compromise the settlement, as the deed into which the parties entered does not require order 3 to be made as a condition precedent to the settlement. And it is not for parties to predetermine or regulate orders that are made by the court. While settlement of disputes is to be promoted, the court should not sanction agreements that abrogate the court's exercise of its powers, including under R 2.28 in a principled manner consistent with overarching principle of open justice. So the intervening parties will say, hang on a minute, we've already seen parts of the documents because they were released in the Dye Chrysanthou matter. And since when do the parties get to dictate to the court what they can and can't do? And that's what that was part of their big argument. Why should Porter go, well, I'll settle with you, but you have to agree to get this removed from the court file. So the intervening parties said that in the ordinary course, when the proceedings settled, the documents remained on the court file available for inspection and in accordance with R32. And Porter should not obtain special treatment merely because the parties had agreed to removal of Schedule 1, 2, and 3 of the defence and the unredacted reply from the court file. And then it was Mr. Dowling used, so it's about his Mr. Dowling's stuff now. But he was saying the fact that he's a public servant, a member of the Crown, and at that time the Attorney General, that the people had a right to see those documents. And so there's some arguments there. So now she's discussing it. So she's summarised all the submissions. Now she's having a discussion about whether or not they should or should not be able to, like says Mr. Dowling's argument in the present case are equally misconceived. So she's looking at the arguments now and going, well, actually, this isn't a good argument. This is the only other observation I will make relating to Mr. Dowling is this: because of the public interest in this matter and the rights of the inspection given under by 2.32 of the court rules, the court established an online file on its website so members of the public could access documents they would be entitled to inspect under 2.32 free of charge. Mr. Dowling's affidavit and submissions will not be placed on the online file, given that they contain apparently scandalous and scurrilous material about third parties. Further, the unsuitability of Mr. Dowling to assist the court as a contradictor to the parties seeking the making of proposed consent order 3 is confirmed by the fact that his affidavit and submissions in support of his position contain extraneous and apparently scandalous material. For this reason, I will dismiss Mr. Dowling's interlocutory application filed the 11th of May, while Mr. Dowling submitted that his costs should be paid by the parties because they changed their position from seeking a suppression to a non-publication order to seeking removal from the unredacted defence and the unredacted reply from the court file. I disagree. Mr. Dowling filed his interlocutory application and has been unsuccessful in obtaining any capacity to intervene. His proposed intervention at all times constituted the activity of an intermeddler. The parties should have an order for costs against Mr. Dowling in respect of Mr. Dowling's interlocutory application. I turn now to relevant issues. Wow. consent orders. So now she's discussing the consent order and why they should not be made in chambers. So she actually did this in court. So and then she's talked about some issues about the court rules. The things that, so while mere embarrassment, inconvenience, annoyance will not suffice to ground an application for suppression or non-publication, and the principle of open justice, that justice must not only be done but be seen to be done, is fundamental. The principle has never been absolute. The principle has always yielded to contrary necessity. In respect to the mere convenience or preference of the parties, the requirement of necessity was explained in Hogan versus Australian Crime Commission. By contrast, the notion that such an order would be convenient, reasonable, or sensible, or would serve some notion of public interest, still less that as a result of some balancing exercise, the orders appear to have one or more of those characteristics. This approach may be contrasted with that in the United Kingdom, where the person seeking access to documents must show a good reason why access will advance the open justice principle. Dring at 47 Rule 2.322 of the Court Rules, in contrast, assumes that the principle of open justice is advanced by public access to the nominated document subject contrary order as identified in R. It appears to me that recognising these matters, there are certain aspects of the Court Rules which may justify consideration of amendment. So now she's talking about Court Rules. So first, unless a document is filed by mistake and is intended to be replaced by a substitute document, I can see little difference between the effect of making a suppression order or a non-publication order of the court. Both orders have the effect of placing the document beyond the reach of the public. Yet suppression or non-publication order may only be on the grounds of specified in 37 AG1, must specify the grounds in which it is made under 37 AG2, can only operate for as long as reasonably necessary under 37 AJ, are entitled to appear and be heard by the court on the application for such a matter. So, yeah. So she agrees. So she goes in and says that she agrees that anybody that is not party to the file should not see the unredacted. And so now she's talking about anomalies. So removal from court file. Against this background, the question whether it is necessary to prevent prejudice to the proper administration of justice for the unredacted defence and the unredacted reply be removed from the court file can be answered. So now she's talking about the question as she's answering it. The intervening parties are right that parties cannot dictate to a court orders it should make. They are also right that in the ordinary course, filed documents remain on court file after settlement. But this does not mean that a party applying for removal of the document from a court file is seeking or obtaining special treatment. The court rules permit that such an application to be made and to be granted, as submitted by Mr. Walker SC, just as parties may compromise a substantive claim or an entirety of a proceeding, so too may parties compromise an interlocutory application. In this case, Mr. Porter's application for Schedule 1, 2 and 3 of the defence be struck and removed from the court's file, and the respondent's response that if Schedule 1, 2 and 3 of the defence are struck out and removed from the court file, paras 2, 11 to PP and 8 of the reply to the defence should be struck out and removed from the court's file. For the court to refuse to make proposed consent order 3 in these circumstances would be to undermine the lawful contractual bargain which the parties struck to compromise all the claims. The undermining of that lawful contractual bargain would operate at two levels. First, as between the parties, the court would be rewriting the contract of the parties. The court would be doing so in circumstances where it does not know, one way or another, whether the bargain would have been reached without the proposed consent order 3. It is true that the parties could have drafted the deed so that the release would be conditional on making on the making of the consent orders and did not do so. However, this reinforces the fact that if proposed consent order 3 is not made, the court would be rewriting the contract of the parties by which they would still be bound. Provided a contract is lawful and the parties are competent, freedom to contract is one of the fundamental pillars of the common law. Further, it is duty of the court under 37M3 of the Court Act in exercising its powers in civil proceedings under the court rules to do so in a way that best promotes the overarching purpose in facilitating the just resolution of disputes according to law as quickly, inexpensively, and as efficiently as possible. Between themselves, the parties have determined a lawful way in which to resolve all disputes between them, and their resolution accordingly reflects the just resolution of disputes between them as quickly, inexpensive, and efficiently as possible. These considerations indicate that it may be necessary in the proper administration of justice to give effect to the contractual bargains of the parties. So essentially it was, well, they made this agreement and the court really wants a courage agreement. So yes, they could have drafted consent orders and made it as a conditional, but they didn't. Second, in the interest of justice overall, these considerations as between the parties remain in play. In addition, refusing to make the proposed consent order 3 may involve prejudice to the proper administration of justice by potentially discouraging parties from settling all elements of this dispute. For example, in the present case, if the parties assumed that the court would not make proposed consent order 3, they would have had 3 choices: to not settle the proceedings at all, to settle proceedings regardless, or to settle the substantive proceeding but conditional on Mr. Porter succeeding in respect to his interlocutory application to strike out 1, 2, and 3 of the defence and remove those parts of the document from the court's file. Option A and C are contrary to the duty imposed on the parties and their representatives to comply with the overarching principle of 37M of the Court Act. Yet B may be contrary to the true objectives of one or both of the parties, driving them to adopt options A or C. Options A and C, however, conflict with the overarching purpose of 37M and thus undermine the proper administration of justice. So now we're talking about the administration of justice. So this does not mean that the court is bound to accede to any proposed consent order providing for the removal of a document from a court file. To the contrary, the principle of open justice, though, although not absolute, is also a foundational principle of common law. So she's now looking at the proper administration of justice. And the circumstances. So circumstances A, before the settlement was reached, Mr. Porter had filed an interlocutory application in good faith, seeking to strike out 1, 2, and 3 of the defence, and for these parts of the defence to be moved from the court file. B, before the settlement was reached, the respondents had indicated to the court their position that if Schedule 1, 2, and 3 of the defence were struck and removed from the court's file, then Para 211 to PP and 8 of the reply to defence would be struck out and removed from the court file. Mr. Porter's interlocutory application had not been determined at the time a settlement was reached. The parties settled the whole of the proceeding, including Mr. Porter's interlocutory application to strike out and removal, on terms which included the filing of proposed consent orders. The terms of these consent orders included proposed order 3, meaning order 3 is part of the contractual bargain for settlement which the parties struck. By reason of the settlement, there has not been and will never be a judicial determination of Mr. Porter's interlocutory application, and nor has there been, nor will there be, ever a judicial determination of any of the issues raised in the respondent's defence. It is these particular circumstances of the present case which cause me to conclude that it is necessary to make proposed consent order 3 to prevent prejudice to the proper administration of justice. Had any one of these circumstances not been present, I may have concluded to the contrary. So I think in that, she's written there that that there will never be a judicial determination of any of the issues raised in the respondent's defence. So essentially, he will never have to face those allegations, and that's what they are. So because the alleged victim now is no longer with us, and so it's only ever going to be allegations. So it's never going to be proven. So it says it's relevant that Mr. Potter was the Attorney General for the Commonwealth and is a Minister of the Crown, and the ABC is a public funded broadcaster. This means that there is a legitimate public interest in their conduct generally, including conduct of litigation. The principle of equality before the law evoked for Mr. Potter does not change this fact. This reinforces the relevant test for making the proposed consent order 3 is not merely whether the parties have consented to it, but whether the making of proposed consent order 3 is necessary to prevent prejudice to the proper administration of justice. So, while ordinary members of the public are well aware of the differences between allegations made in court and findings made by court, the matters in Schedule 1, 2 and 3 of the defence remain allegations which will never be the subject of judicial determination given the settlement of the proceedings. Porter's allegations that those schedules are a form of an abusive process will also never be subject to judicial determination. And in these circumstances, given the full compromise of all aspects of the dispute reached between the parties, I am satisfied it is necessary to give effect to proposed consent order 3 as an important aspect of that compromise, and to that extent the principle of open justice must yield. This conclusion has nothing to do with the fact that the parties may warrant the description of power litigants. The parties are not obtaining special treatment or extracting from court any protection greater than ordinary parties. It is open to any party to apply for the same kind of relief as the parties sought in the present case if the circumstances arguably justify the making of such an order. And then she talks about arguments of the intervening parties that they had remained. So one, I do not accept their argument based on the alleged lack of utility. It is not to the point that some or even most of the information in Schedule 1, 2 and 3 of the defence may otherwise be disclosed in information released by Thorley J, consequential upon Dyer. This does not change the fact of the compromise the parties reached in this case, including filing the proper consent orders. 2, I do not accept that I may make proposed consent order 3. I need to have concluded that Schedule 1, 2 and 3 of the defence constitutes a form of abuse of power, abusive process, and should be struck out without the meaning of the court rules. The purpose of the settlement reached by the parties included avoiding a judicial determination of any issue in the proceeding, including in respect of Mr. Porter's interlocutory application to strike out and remove from the court file 1, 2, 3 of the defence. The essential purpose of the compromise would be lost if, in order to accede to the consent order, I had to find that Schedule 1, 2 and 3 of the defence did not include a form of abuse of power. So she's saying that even though the redacted defence was released in Dyer and Chrysanthi, I'm getting the impression that this is only in relation to her court file. So the appropriate forms of orders be made, recognising that the redacted defence and redacted reply have already been filed and remain on the court as is follows. So Mr. Dowling's stuff is not being put onto the court file. So she says, I noted above, I did not propose to place the submissions or affidavit Mr. Dowling on the court online file because they contain scandalous material. I will otherwise make arrangements for the following documents to be placed on the court file: Mr. Dowling's interlocutory application, Mr. Porter's submissions in support of the proposed consent orders, the ABC submissions, and the intervening submissions. So it looks like the redacted defence and the redacted reply will remain on the court file. So it's the unredacted stuff. So they're the orders that we know. So leave is granted to file a discontinuance. So that is the orders. So it looks like we will never know what is under there. We won't know what was unredacted. Although the redacted stuff, in my opinion, was pretty damning from what I saw. We did look at those, and if you go back between the Porter and the ABC files, you'll see the unredacted stuff. It's pretty damning, the redacted stuff. So it's going to be really interesting to see what happens here. I don't know that anyone is appealing. I think everyone's just accepting it. We know that we can get the redacted stuff. Looks like it's going to be still available, I guess, which is good. We'll just now see what the South Australian coroner determines. There's lots of talk around. I've heard people say that they're going to do a private prosecution against Porter, against his alleged victim. I don't know. There's lots of talk going around between different people who are trying to get justice for the alleged victim, but I don't know. But I'd be interested to hear what you say. I apologise for the pause in the middle. There was something happening in my street that distracted me, but I really just wanted to do this in one go, get it done. And anyway, thank you for joining me. Please hit the like button, subscribe, and look, you can always show me some thanks by hitting the thanks button as well. So thank you for joining me, and until next time, I will catch you again soon.